in Clayton Echard, case FC2023-052771 for Ms. Owens. Counsel, do you want to make your appearance?
Yes, Your Honor. Attorney Joshua Lopez representing the plaintiff in this matter, Laura Owens, who's present before the court, sitting to my right.
Thank you. Nobody has to stand up again, okay?
Okay.
Not even you. All right.
Okay.
So, Ms. Owens, please tell me your name and date of birth.
Laura Owens, 5/14/1990.
Thank you. And Mr. Echard, sir, tell me your name and date of birth.
Clayton Echard, 4/29/93.
Echard, thank you. All right, I'm going to administer the oath. Do you both solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. I'm just before we start, there was a motion to allow plaintiff to appear by phone. I denied it last night. And then there's another motion from the plaintiff this morning. Oh, it says attorney for defendant, but that's a typo, right?
That is a typo, Your Honor, and it's my understanding, at the same time I was unaware, yesterday there was the hearing, and we had a hearing yesterday. Mr. Clerk, Mr. Echard was the petitioner in that matter in an injunction against harassment matter.
Oh.
That was available for individuals to access that hearing online via the court's website. It's my understanding in order of protection hearings that online access is not available.
That's what I was told by staff.
Okay.
So I'm just going to deny it as moot.
No problem.
Your second motion,
Okay,
which
thank
is
you,
to request that the hearing be closed from the public. Well, that's a non-starter, pretty much.
Okay.
That's really rare.
I understand.
I mean, these public hearings. But at the same time, or that the hearing be closed from watching online. I'm told by my staff that we don't do that. It's just not set up to do that today.
Okay, thank you.
You're welcome. So that's denied as well. Anyway, we'll file your, let me just give this to you so you can file it after the hearing. There are real kind of unusual rules attached to orders of protection. So. All right, I've read the petition. Folks, the way I run all of this is just, where do you go? Is he down there?
Yeah, he's plugging in.
All right. The way I run all of my hearings on orders of protection is they give us a time slot of 45 minutes. So I always start out by saying to people, each side will get 20 minutes to put on their entire case, and that includes me looking at any exhibits you might have. And the way the sequence of events will be that the plaintiff gets to go first. I want to hear her view of the matter, her story, and she can include her exhibits, as to supplement what she's saying. And then after plaintiff is done testifying, then I'm going to invite the defendant, Mr. Echard, to ask questions of the plaintiff if you have any. You don't have to have any, and I don't take any inference from whether you have them or not. So once that process is done, then I'm going to invite the defendant, Mr. Echard, to tell me what happened from his point of view. And we'll consider the exhibits that he has. And then I'm going to invite counsel for Ms. Owens to ask Mr. Echard any questions if he has any. Again, you don't have to have any. And then finally, here's the other motion. And then finally, I'll give Ms. Owens an opportunity to sum up or to do a rebuttal to what Mr. Echard said. Okay? So it's a really good idea not to use up your whole 20 minutes in your initial presentation. And the defendant too, if you want to reserve some time to ask questions, try not to go over your time. If both of you have been efficient, if you've been efficient and you need more time, and I think we need more time, we're going to do that. But I want to make that judgment when I get there. I don't know. It depends on if you're not efficient and you're going off on different things that don't really have any relevance to this, then I probably will not allow more time. So with that said, I will invite Ms. Owens to put on her case. You've got 20 minutes, Mr. Lopez.
And Your Honor, could I do a brief opening?
Of course.
Okay. Let me just start my timer. The evidence will show that Laura and Clayton had a romantic relationship back in May of 2023. Laura became pregnant with Clayton's twins. They are due in February of 2024. Since that time, Clayton has disputed that Laura is actually pregnant or that he is the father of their unborn children. Clayton has made it known to Laura that he hates her, and this has caused him to post harassing information about Laura to his hundreds of thousands of followers online. The evidence will show that Clayton has committed domestic violence within the meaning of the statute in multiple ways within the past year, and that there is a likelihood that this unlawful conduct will continue into the future if this order of protection does not remain in effect. We will request at the end of this hearing that it do remain in effect. Thank you.
Oh, you're welcome. Okay. Start by establishing the relationship and then including whether they've ever lived together, and then take it from there.
Okay, thank you, Your Honor.
Sure.
Laura, how do you know Clayton?
He was my realtor to start with, and then we were intimate one night in May of this year.
And when you say intimate, is that a sexual relationship that you had with Mr. Echard?
Yes,
Where was that?
that was at his house.
And is his house located in Scottsdale,
Yes, it is.
here in Arizona,
Yes,
and within Maricopa County?
yes.
All right. And after that encounter with Clayton, was that back in May of 2023?
Yes, it was.
And what happened from then?
From then, well, we had a real estate transaction that went wrong. He ended up getting in trouble with the A.R.S for not submitting my offers, but that happened a few months later. After that, on June 1st, I found out that I was pregnant, and I figured he probably wouldn't believe it, so I went to urgent care, to Banner Urgent Care, and had it confirmed there by a doctor, and then I told him.
Okay. And was there anybody else other than Clayton that these unborn children could belong to?
No, I hadn't been intimate with anyone else since March of 2022. I was violently assaulted and raped, and I had hang-ups for a long time.
Okay. Now, since then, what has your relationship been with Clayton moving forward?
Well, I've tried to get Clayton to accept responsibility and figure out a parenting plan with me, but that's really been it. It's not like it's been a dating relationship, and yeah, I mean, we've communicated via email for the most part.
Okay. And has he posted anything online or sent you communications indicating his hatred toward you?
Yes, he has.
Please avoid the leading questions.
Has he sent communication to you?
Yes.
Okay, and what is that in regard to?
That has been in regard to how he feels about me, and how he hates me, and that doing this to him, meaning making him be a father, would be his idea of being in a living hell. He's told me he wanted 100% custody, despite also claiming I wasn't pregnant, but then he said I should take 100% custody. He also said that when we thought it was just one baby, would be put up for adoption, and then he said that he wanted me to have an abortion.
Okay, so I'd like you to turn to Exhibit 1. What is that?
These are text messages from Clayton to me, just threatening, really, saying that, I needed to back off on, basically on saying I was pregnant, and then he referred to, he hates me, he demanded he talk to my mom, which he did, and then he said people like me needed to be held accountable if I was lying about being pregnant, which I clearly was not. He said that when his mind is rooted in anger, it doesn't sway, which I took as threatening, and then we have about him saying about an abortion or adoption.
Now, these text messages, are those from Clayton to you?
Yes.
And were those within the past year?
Yes, they were.
Since May of 2023?
Yes.
When you became pregnant?
Yes.
Okay. What happened on 9/21/2023, as you stated in your petition?
That was when Clayton posted on his social media, that had a big following, that I had 2 identical cases, and tried to present me in a very false light to his followers.
Did Clayton ever indicate to you that he wanted you to prove to him that you were pregnant?
Yes.
And did you take steps to do that?
Yes, I did. I went over to his house and took a test he bought in front of him, and I peed on a stick in front of him.
Okay, were there other things that you did to show Clayton that you were in fact pregnant?
Yes, I invited Clayton and his family to go to my first ultrasound with me, which his family didn't respond and he didn't go. And I asked about taking a prenatal paternity test, and this has been an issue with him and I going back and forth as to who to take the paternity test, but I proved that I paid for it in August and he did not show up for his portion. He didn't schedule it.
So did you ever send him a video showing him that you in fact were pregnant?
Yes, I did.
Okay, I'd like to turn the court to Exhibit 17, and Your Honor, I'd like to admit Exhibit 1 into evidence.
Any objection to Exhibit 1, the text messages?
Yes, I'm trying to pull it up here. I got it sent via email. I would just simply object on the basis that I think there's missing context. It's a text message where no context is provided, and considering the circumstances that I do not believe her to be pregnant, I believe that I'm the one being harassed. So I don't believe that I ever have harassed her.
Okay. I think the context can be shown when it's your turn. You can fill that in. Okay. So overruled, I'll admit Exhibit 1. What's the next one?
Your Honor, I'd like to present, and I'm skipping around here because of the limitation of time, but Exhibit 17, Your Honor.
Okay.
And I can bring it's a video, I can bring it up to
What?
The court doesn't have a video in hand, so that would be it's going to be the last exhibit on the list, which will be Exhibit 52.
You don't have a video in hand?
No, I don't have a video.
Did you give her a thumb drive?
I did give him a thumb drive yesterday, Your Honor.
Okay, so if it's in there, it'll be Exhibit 52 because our exhibits are numbered differently than how you guys submitted them. So it'll just be Exhibit 52.
Did you give Mr. Echard a copy of the thumb drive?
I did, Your Honor.
Good, okay. All right. Tell us what's on it so Mr. Echard just doesn't land in his lap.
No
And he
problem.
has a chance to object.
Okay.
So what is this? Lay a foundation for this video.
Okay.
You've already talked about the fact that she offered to all the stuff that she did to show Mr. Echard that she really was pregnant. Paternity test, she said he didn't show up for it. All that stuff. So what is this a video of? Is it him or is it somebody else on the video?
Who
What
is
is
the video
this?
of Miss Owens?
It's of me showing that I was pregnant. It was a video of me turning to each side to show that I was pregnant.
And did you
Okay.
send that video to anyone else except for Mr. Echard?
The video on 9/20.
The video that you just disclosed regarding your pregnant stomach?
No.
Okay. And did you ever find any harassing information regarding that video online after you sent it to Mr. Echard?
I think you're referring to a different exhibit, actually. The Halloween one?
Yeah.
Because that was, one was a video and one was a photo.
Did you ever send?
This had an image, so exhibit 11 is a screen grab of a Reddit thread saying how to win the scariest costume contest, and it's me turned showing my stomach, and it's me holding a sonogram of our son that only he had possession of, so he clearly made this up of me, which obviously was offensive.
So in Exhibit 11,
Yeah.
our Exhibit 11, that is a picture that you had sent to Mr. Echard.
Yes.
You did not send that to anyone else, or did you?
This was sent to somebody in the press, but they weren't supposed to publish it. But the sonogram that I'm supposedly holding was, that was not sent to anyone else other than him.
Okay. So was he the only one that would have been able to post that?
Yes, he was.
Okay. Your Honor, Exhibit 11 I'd like to admit into evidence.
Any objection?
That's the one with the picture right there. Just want to
Yeah,
make sure you can admit that.
okay, thank you. Exhibit 11 is admitted.
Okay,
I think.
moving forward, let's talk about
Well, tell me, what channel did this have any connection to her, or besides, her image, her face is not shown.
Mhm.
So does this identify her in any way?
So it does because of his image. People on Reddit, there have been just thousands of people who have posted on this about me, and so this was just another post about me, but I've been identified on Reddit. And this image was shown. Somebody had gotten this image on Reddit, and it was with my face. They just took it out for the purpose of this post.
Okay.
now. Is it your understanding that Clayton had posted online regarding misinformation regarding your pregnancy?
Yes.
Okay, and what happened after that?
So Clayton posted a video on 10/6 on his Instagram that I believe we have, and it was him saying that there had been test results back from the lab, from the prenatal paternity test, saying that the results came back and there was little to no fetal DNA, and that he wasn't the father, and like it's a great way to start off the week.
Now, was the paternity test over at that point?
No, it was not. It still is not over.
Is it ongoing?
It's ongoing, and that's what I was told by the lab. They said that they got a diluted sample and that they needed me to submit a new sample, that there was little to no fetal DNA within that sample, but obviously not that there wasn't within me. It was some issue with transit, so they had me come back and take another test.
After Clayton made that post, what happened in regard to his fans and followers?
His fans and followers went absolutely wild on me, harassing me, telling me that I wasn't pregnant, or that I had filed this false case against Clayton. And the press ran with the story we have with Exhibit 12.
Is that post that Clayton had posted online, is Exhibit 16 that video?
Yes, it is.
Okay, Your Honor, I'd like to move into evidence Exhibit 16 and then publish it for the court.
Mhm.
All the videos are gonna be on Exhibit 52. They're not separated out.
I see.
Exhibit 52 then, Your Honor.
Okay, any objection to my looking at this video that he's,
No, I made it public, so.
okay, then go ahead. That's admitted then. So we're gonna watch it over here?
I can put my computer wherever is best for the court to.
Well, why don't you go ahead and put it on the witness stand, and I can see it there, and Mr. Echard, you're welcome to come up and look. And, you probably should, but
Well, I can. I mean, I know the video.
come on up anyway. That way you're not gonna feel that you're like.
You know what we need on a Friday? We need some good news. And who's got the good news today? I got the good news. What's that good news, Clayton? Well, test results came back early, and they said little to no fetal DNA present. Let's go, baby. We knew, I knew that was going to happen. Thankfully, 5 months of torture can finally be put to rest. I want to say thank you all to those that have supported me and waited until everything came out. And man, 2 false accusations in 2 years. I really don't want to, look ahead to next year and see what's going to happen. I think 2 false accusations in a lifetime is enough. So thank you all for the support, love. This was a trying time, but I learned so much about myself. And now back to the regularly scheduled programming, baby. Listen, it's Friday.
Ms. Owens, did you ask Clayton to take down that post?
I did, yes.
Were there other posts that you asked Clayton to take down?
One was an Instagram story that he had that expired after 24 hours, but he didn't take it down.
And what was that Instagram post in regard to?
That was saying that I had posted to I had made 2 identical allegations against 2 other men.
Okay. And in that video where he indicates that the results came back early, was that true?
No.
Okay. Were the things that he was posting online causing, or was it known to him that it was causing you to be harassed by him and his followers and fans?
Yes, it was. I made that very clear. And also the news headlines that came back were causing that as well.
And did he ever take down those posts?
The Instagram story expired after 24 hours, but the other post, no, that's still up.
Okay. Now, what happened on 9/21/2023?
When was this Instagram post, by the way, that you've referred to?
That was on, I think it was 10/6.
Do you have any pictures of it or anything?
Of which post?
The Instagram post.
The one from 10/6, the one we just saw.
Yeah, the one you just talked about.
Not the video that was shown. A different one.
The one that expired after 24 hours.
Oh, I have it on my phone, but I didn't print it on, yeah,
All right, fine.
yeah, I do have it.
Well, okay, but it's not, your testimony's evidence, but
Okay.
I was just asking if there was something to, so, okay. All right, go ahead.
And let me just bring you back. And
And
then,
a time check, by the way, you got about 4 minutes.
all right, did you ever talk to?
Do you want to do this one?
You know that the paternity test is not over, is that right?
Yes,
And you had, after you had seen the different posts that Mr. Echard made online, did you speak with the lab regarding those?
yes, I did.
And when you spoke to the lab, what did they say?
They said that the testing was ongoing, and they said that Clayton very well knew that the testing was ongoing despite having posted that.
Okay, and do you have a phone call with the lab in regard to that?
Yes, I do.
Okay, and that's our Exhibit 18. I believe that the court clerk has indicated it's Exhibit 52. Your Honor, I'd like to move into evidence our Exhibit 18, which is a phone call with my client and the lab.
Any objection?
No.
Okay. All right, it's admitted. And that's just audio, right?
Yes, Your Honor, it's just audio. Can I come up and
Sure,
for the court?
you can.
Okay.
You're welcome.
I can sit here.
Okay, do you think he understood that the result wasn't back and I needed to take the test again?
Oh, yeah, definitely. Yeah, definitely.
Okay, so
We're still testing. I haven't told the date that you were scheduled for all that yet.
yeah, okay, so he did understand. It wasn't like there was any misunderstanding, you don't think?
No.
Okay,
Yeah.
okay, because I didn't know if maybe calling him would help, but if you explained it the same way you did to me, then I don't think there would be.
There's a date. The date we're tracking. We'll get it Thursday, purified, run it Friday, and it should be coming. Same schedule should be coming out Monday afternoon or so. And as soon as it does, we're gonna give you the result.
Okay, so he did understand it wasn't that the test still came back early, like you said. I think he maybe, well, you know what, I'm sure he understood. That's it. Yeah, I'm sure he understood. Yeah, 'cause
Yeah.
from your guys' standpoint, you've had it before where, like, the sample comes back like this, and that doesn't mean that pregnancy is not there anymore. I mean,
No. Yeah, it's just we need another sample to finish up testing. So once we get that, yeah, we'll be giving you a call, let you know.
okay, so it just needs to be more concentrated, basically.
Yeah, for fetal DNA, we need a percentage high enough that we get accuracy beyond 99%. We don't have that with this first sample. So hopefully you come into the site holding off on drinking water, just so we don't dilute any of that fetal signal. That should be quite helpful.
Okay.
Laura, has the harassment text messages, posts online, has that caused you a great deal of distress?
Oh, yes, absolutely.
And when I define distress for me, what's been going on?
I haven't slept well at all. I'm thinking of this all the time because I'm getting harassed by people who are even, I've had a ton of them who've contacted my parents and my brother-in-law and my sister, acting like I am crazy and like I have, quote, done this before when I wanted to address that because I know that he's going to address that these two identical allegations. I've never had a paternity case against somebody. I do have 2 orders of protection against 2 men who I got pregnant by. The pregnancies are verified. That's we admitted that into evidence as well.
Let me just stop you. Are you pregnant?
Yes.
Okay, can you stand up for the court?
Yes.
Now,
I'll take her word for it. Everybody seems to be assuming that. All right, you're you're out of time pretty much.
okay, can I just ask one?
No.
Okay.
Mr. Echard, do you have any questions for the plaintiff? You don't have to have any.
I do, actually.
Then you go ahead.
Yes,
Questions? Okay, don't argue with it though. Okay?
yes. Ms. Owens, did you send me via email an ultrasound video?
Yes.
You did? Okay. That was sent by you, okay. Did you also send me an ultrasound photo via email?
Yes, I did.
You did? Okay.
But the video
Do you
was not
have-
the video I was trying to attach for you.
So the video that I received,
Yes.
you sent that video?
Yes. That's my understanding.
You
You
sent
said
that
that
video?
you got the video, so.
Okay. I will show the video when it's my time to present, that I'm speaking of. And the ultrasound picture that you sent me, or you had your lawyer show me,
Mhm.
do you have an ultrasound report that comes with that?
Yes.
You do? Why have you not presented that as evidence?
Because
Objection, Your Honor. That sounds like health information that she doesn't have to disclose her health information to the court.
Overruled. You can answer.
I offered you a HIPAA release to get my health information as recently as I think last week, and you didn't get back to me.
I'm not going to argue with that, but that's false. Did I ask you multiple times early on to take a paternity test?
Yes, as did I. I asked you the same thing.
And did you place stipulations upon that I had to date you exclusively in order for you to take that test?
For 2 weeks in order to take it early. Otherwise, I would just wait until the birth of the children was required of me by law. It was if you wanted to know early.
So you're agreeing you would only take the test if I were to date you exclusively?
I think you're mischaracterizing what it was. It was so we could make a decision as to whether or not to even proceed with the pregnancy.
This is his time.
Yeah.
So I'm going to ask you to just answer his question, yes or no, if you can. If you're unable to, just say I'm unable to answer it.
Okay.
So, Mr. Echard, ask the question again.
Yes. Did you state to me that you would only take or do a paternity test if I were to date you exclusively?
At what point?
Within the first two months?
Yes.
You did state that?
Yeah.
Okay. Last question. Would you agree that only oral sex was performed the night that we were intimate?
I would not agree with that.
What would you say happened?
I explained it to you in an email. You said you were insanely high that night and clearly do not have full recollection of what happened. Do you want me to explain it to the court in detail, or?
I'm okay with that. Explaining what happened, yes.
Okay.
I remember everything, but yes, go ahead.
I remember everything as well. You were asking me when we were
Your Honor.
naked and.
Your Honor.
Just a moment, please. Did you have a legal objection?
Yeah, I'm going to object at this point. I think this is a little bit outside of the scope of what this hearing is in regard to this specific. I think that I've laid enough foundation. I think it presented enough evidence to show that there was a romantic relationship. Mr. Echard actually, it sounds like he's acknowledging that by his question. Getting into the details of what sounds to be potentially sexual intercourse on the date of this, of what happened on that night. I don't think that needs to be presented in testimony to the court.
I think to some degree I sympathize with that. Mr. Echard, to go step by step about who took whose shirt off first kind of thing is really kind of beside the point. It's salacious and it's an invasion of both of your rights of privacy.
Okay.
But what I would think is legitimate is to say, did we have sexual intercourse,
Yes.
where, a person could become pregnant, you can ask something like that.
Yeah,
right?
and I guess I'll ask that directly. Did we have sexual intercourse that night?
Yes.
All right. So you're finished with your questions?
I am.
Okay, then I'd like to hear what you have to say about everything they've presented. Try to focus on what they presented. Everything else is beside the point, because I'm just focusing on what they put into evidence, not their allegations, but what's in evidence.
Sure. So I would just like to state again, I guess I can address first the video that you saw. I had mentioned that I had been tortured for the last 5 months. The reason, and I did state that the results of the first round of the prenatal paternity test came back and it showed little to no fetal DNA, which is in fact what was stated to me. This led me, aligned with what I believed, that she is not in fact pregnant with 5 months pregnant with my twins, which I have questioned the entirety of this time. I have not been able to receive any evidence proving that she's 5 months pregnant with twins. When I've requested it, she has not given it to me. We did an early resolution conference last week. The mediator asked for her to make a phone call to the facility. I will present this evidence, the ultrasound photo, to make a call and confirm that she did in fact do that test there. She was not willing to do so. She has not allowed me to speak to any of the doctors that have administered these ultrasounds, which of course has caused me to question her for that very reason, that it should be a very simple thing to do. She states that she invited me and my family and I to an ultrasound. For one, my parents live in Missouri. Two, they don't believe her. And three...
Objection, Your Honor, speculation.
Well, they
Overruled.
don't.
Go ahead.
Yeah, they don't.
Go ahead.
And beyond that, I actually asked to, I did not want to go in person and see her, but I did ask for her to FaceTime me while she was there. She then canceled that ultrasound, and stating that she wanted her sister to be there to see the ultrasound for the first time. So, and then when it was time to reschedule the ultrasound, she then stated, I feel unsafe, and therefore I do not want you to know when I'm doing the next ultrasound because I'm afraid for my safety. So she then did not tell me when she did the next ultrasound, and that, in my opinion, was her way of getting out of being able to FaceTime me while she was there with the doctor. So, with all of the times, all she has presented to claim that she's pregnant is a visual image of her stomach and a positive HCG test, which that is not enough evidence to prove a viable pregnancy. Under normal circumstances, HCG, yes, that hormone is present whenever an individual is pregnant, but that can be manipulated. The proof that she states that she's submitted in prior cases was the same positive HCG test. That was it. There was never an ultrasound or report, or a OBGYN or a doctor willing to corroborate her story. And that has been the case as well. She mentions in the previous cases that they are not exact, and I would state that sure, they're not exact if we're going to be very specific with our words. But what I can state is she's claiming that she's 5 months pregnant with my twins after we engaged in not sexual intercourse, but oral sex. She's claiming that we engaged in sexual intercourse. I deny that. She performed oral sex on me. There was no penetration. But after one time, she's claiming she's pregnant with twins. In her previous court case, which is publicly accessible, and I accessed the documents, and that's one of the exhibits that I would like to show, she she claimed that she became pregnant from an individual after they engaged in sexual intercourse, and she became pregnant with twins. In the court case that I have here as evidence, there's an ultrasound that was sent to the defendant in which she states in the text message that she's pregnant with twins. So considering all of the evidence, I believe that she has engaged in repeated patterns of behavior. And with all of that being said, I do not believe that she's in fact 5 months pregnant with my twins, because I have not been able to receive any evidence of proof that that is in fact the case. She would need to have an ultrasound report and a OBGYN or doctor willing to back up those claims, and she has not presented that.
Okay.
So that is my rebuttal to any of that. As far as the harassing messages, I don't believe I'm harassing her. I never did. I stated that if she's lying, she'll be held accountable, and I don't believe that's a threat. She attacked me as a public figure. I have a large following online. I was on reality television, and she decided to open a court case against me, this family court case. She then decided to leak this to the Sun anonymously so she could protect her name. But
Objection, Your Honor, speculation.
Yeah, how do you know that, tell me, you just said she decided to leak this to the Sun.
yes,
What's the Sun? Is that like a tabloid?
the Sun is a tabloid, and I have I did not submit the evidence today, but I do have emails and text messages of her. Well, actually, I did actually submit something. She did threaten to go public. Yes, I do actually have an exhibit in here.
Oh.
She threatened multiple times to go public.
Oh, okay, that would be relevant.
And so I can show that. And
Well, why don't we see it?
do you want to see it now?
I think it's important.
It is, let's see here. Let me go public and see right here. Okay.
Refer to your exhibit number.
This is
for the
exhibit
clerk
16.
case.
I'm going to slide this up on the screen here.
Exhibit 6,
So
they've been renumbered.
Yeah, he submitted a couple exhibits that were numbered the same, and so it's a little,
Right.
yeah.
So this is his exhibit 16, but what exhibit would this be on our? You don't know? Hold on, I have, the problem is that there are a lot of exhibits and we have little time to put them together, so let me find your exhibits. Oh my God, quite a few.
Yeah.
So what's your title on this one?
Threat to go public and shame me. Exhibit 16.
That's what it says?
So
Yes.
exhibit 35.
Okay. Got it.
There's 34 and 30.
34 and 30, which one, 34 or 35 do I well,
34.
he doesn't know.
It's not on the screen, Your Honor. I don't
Can
know.
I turn this around? Oh, let's see.
Yeah, right click on it on your computer.
Oh, thank you. I remember that now. Oh, there it is. I don't want a 7-day trial. Go away. Oh, no, just go. Won't let me. Okay, but I can, obviously do this. So let's see. So why don't you lay a foundation for this?
Yes.
Oh, it's right up there too.
Yes.
Why don't you lay a foundation, date, how did you find out about it? Where did you download this image?
Yes.
What date? And give me some context.
Let me see if I can scroll up here. So this is,
I can see it on my screen.
yeah, it should say the date. I can't see the date from here. But it should be in the top right. So she says in this
It
email.
just says yesterday, so that's
Okay.
not helpful.
Okay, in this case, this was sent within the last month. As far as the exact date, I don't have it, but it was.
Within the last month?
Yes, because
Okay.
this is when or probably about a month and a half ago.
Okay.
So she states in here, if you want option A, I will not post this. Option A dealt with a dating stipulation. She said, I'm just looking for support during this incredibly overwhelming time. And so then she states here that she's going to put up a post. The caption, surprise, can't wait for the arrival of these two next Valentine's Day. How she knew she was going to deliver on February 14th is beyond me. But she stated on a more serious note.
I can read that. I'm just trying to get
Okay.
the context. You've already
Yeah.
laid the foundation.
Okay, sorry.
And where did you get this?
This is a screenshot from an email she sent me.
I got you, okay. So, do you have any objection to me considering this exhibit?
objection, Your Honor.
Okay, then, exhibit 34 and 35, have you seen 35?
35
Let's
should,
look at 35.
if it's the one, I know, it's the one of the post with the two,
Echard twins coming February 24.
yes.
All right,
No objection.
okay, so both of those will be admitted, okay? So, I can read them, you know,
Sorry,
if that's okay.
Yeah.
But if you want to read them yourself, it's your case, you tell me how you want it.
I just, yeah, sorry, I didn't.
You want to read it, you can.
Well, I just wanted to lay some groundwork, but I didn't mean to.
I just closed 34.
I would like to move over to my video.
All right, let me just read this first, though.
Okay.
I can't believe I can't do. This is so lame. Okay.
We do not have a video for him, by the way.
Oh,
The video, I have a USB drive here.
Okay, perfect.
all right.
Do you have a copy for him?
Please give that to the clerk in one.
I gave them a copy. I have one,
Okay.
and here's one for you.
That works, thank you. Exhibit 53.
Okay, let me make sure I got all of it because, all right, I got it, all right. So, let me just look again at 34. Or 35, I mean. And so what's the context of 35? When did you get this?
That was in the same email.
Oh, I see.
Yes,
And this is from the plaintiff, Ms. Owens?
correct.
Okay, got it. All right, so what do you want to need to see next?
So I'd like to admit this exhibit, if possible. So this is
This is also part of Exhibit 52 because you put all the videos in
No,
one?
53, this is defendant's 53.
So this will be defendant's 53?
Yes.
Okay. Lay some groundwork
Yes.
so they can have a chance to object. Okay,
Yes.
what are we going to be looking at here?
So what you're going to see is two screen recordings. The first screen recording is showing my email inbox that this message was sent from Ms. Owens. Within the message, you'll see the ultrasound video that she earlier stated she sent to me. Then the second clip you will see is a screen recording of a YouTube video from 6 years ago. That video contains the exact same video that she sent me. So you will see that these videos are identical, and this ultrasound video that she sent to me is not her ultrasound. It is a ultrasound that she stole online.
And Your Honor, I'm going to object to that because the scope of this hearing is, again, whether they had a domestic relationship and whether there has been domestic violence by Mr. Echard toward my client, Ms. Owens. Regarding paternity, regarding her pregnancy and regarding what maybe she sent to him isn't within the scope of this hearing. What this hearing is in regard to is whether, again, they had a domestic relationship and whether he has harassed her by putting things online when there's now a court order forbidding him to post false information. What he sounds like he's trying to show, again, it doesn't have, that's outside the scope of what this hearing is about.
I will consider your objection in deciding what weight to give the evidence, but, and to some extent, I think there's some validity to what you're saying, but I'm going to give Mr. Echard an opportunity to basically what he's trying to do, and I believe at least, is to show me that this is something that the plaintiff has done before as a way of, I don't know, somehow benefiting herself. And that, she created this whole situation. And that if he whatever he did was some sort of legitimate self-defense to protect his reputation because she threatened his reputation. I believe that's where he's going with this.
Correct.
And so I'm going to decide, I have to decide what weight to give it and whether that outweighs what he's done. But I think it's legitimate to allow him to put that into evidence, so I overrule. Go ahead.
Thank you.
You're welcome.
So I will play this video again. You can see within here it says ultrasound video proof, and so I will play this video. I'm going to just pause it so I can give context throughout.
All right, remember, let's do a time check. Oh, you're almost out of time yourself. How much do you, how long?
I mean, this video looks like 2 minutes. I mean, I do have additional evidence that I feel is important to try to submit.
Well,
but this is the most important one.
go ahead, play it.
Okay. So this is showing that this is the email she sent me. She says here is whatever percentage that is, 1,000,000% a real ultrasound video.
And when did you get this?
Does it state on here? This is probably within the last month. Oh, it should say up there on the at the top right. Maybe
You have it on your computer. Can you magnify the view?
Oh, let me
Just
see.
tell
Yeah, let me pull up. Oh, it's gonna pull up the same one. Yeah, let me pull it over here so I
Or
can.
even just look at, the information, get info on the file.
This is Friday, October 6th. Yeah, it says October 6th.
All right, and is that about when you received this?
Yes.
Okay.
So this shows that this was sent from her. I just pulled up that her contact info.
Okay.
Now what's going to show, this is the ultrasound video. I want to highlight the, you'll see it'll say baby A, baby B, and placenta, and that's important. Again, I want to focus, here's baby B, then placenta pops up, and then it says baby A. And so again, I just want to show that this video, this shows B again, and this is the video that she sent me and claimed to be 1,000,000% her ultrasound. Then it shows A. And then it comes here, it shows B and A again. And this is the end of the video. Should be right about here.
Okay.
Okay. So that is what she sent me directly to my email stating that was her ultrasound. Now this is a screen recording from a YouTube video that I found of a video that is what I believe to be the exact same video.
All right, now, how can you connect this video with the plaintiff? You have to do that first. It can't just be of someone that you just found on YouTube and you're saying it's the plaintiff, but you can't prove it's the plaintiff.
I'm stating that this is not, this video that I just showed you.
Let him speak first. Go ahead.
The video that I just showed you is within this video. She took that ultrasound video.
She used the exact same video.
Correct.
But I'm not an obstetrician. I don't know. How am I going to be able to tell that?
I think with the video you can see it's the exact same, and it even says baby A, baby B, placenta. It's all.
Did you put baby A, baby B on the first one that I saw?
That was already on there.
That was already on there?
Yes.
Oh, all right. So, okay. So how do you know, besides the fact that this baby A, baby B, how did you find an ultrasound and connect it with the plaintiff?
I was searching online because I did not believe it was her ultrasound.
Did you search under her name? How did you search?
So I was actually tipped off, and this was eventually sent to me because I do have a large following, and they then shared this video that was online. It found its way online because she did send this to the press. She sent that video to other people.
Objection, Your Honor, may I make a record?
Yeah.
It already sounds like this has been available to other people. It was sent some way. I'm questioning now the authenticity of this video. I don't think that this is admissible for evidence. I don't think he's laid enough foundation for this. It's confusing about how he got in contact with this video. Apparently, my client sent him something, and I just don't think this should be admitted. And if it is admitted, then I think that the court should give this very little weight.
Did you publish the first video, the one she sent you? Did you publish that online somewhere?
No, I did not.
Did you?
It was sent to the press
By whom?
by me. But it was not the same video that was sent to Clayton. I sent him a sonogram and I sent the press a sonogram.
Well, but the only thing that bothers me is he did make an objection that it has some validity here, and that is that you're not the one that downloaded the second video, and so it could be that they just downloaded the same video and told you that it was from years ago to some other person, and so that's legitimate. That's a legitimate objection. How can you connect? How can you prove, first of all, that this, where the second video was obtained, and how can you connect it with her other than the fact that it has the same markings?
Yeah.
And how can you assure me that your follower didn't just send you the same video that we just watched and said, oh, this is from something that Miss Owens posted years ago in another case? How do we know that?
Fair. Yes. So the reason why I screen recorded the first part was to show you that she sent that. That came from her email.
I got it.
So that video she sent me directly. This video is, I wanted to show, that this is a YouTube video. You can find this on YouTube right now. And so it's publicly available. But she claims that this is her video. This video is 6 years old.
How do you know that?
Because it says that it was posted 6 years ago on YouTube. It shows that when it was posted.
Your Honor, again, I want to object because in any ultrasound or even like sonogram, for example, they're going to look very similar. I don't know how by just viewing something like this it's going to show one way or the other.
He's saying that the markings are the same now. But that could be because what she sent to the press is something that, you know what, I think I'm going to sustain the objection for lack of foundation, but I'm going to admit the fact that the defendant at least believes that this video from his follower is truly a representation of a video that the plaintiff sent because of the markings are the same, and he believes his follower who took it off of YouTube. And he says that he checked YouTube himself and verified it. So that shows his state of mind for what it's worth. Okay, but I'm going to take your word for it that this video is going to look the same as the other one.
So, but you won't admit it, but would you still watch it? Would you still watch it or no?
Your Honor.
No, if he objected and I'm sustaining the objection, I have to be consistent with that. But I'm going to let this, I'm going to basically say that you're basically saying that there are other videos out on YouTube that I believe are from another case, and that's, that's something I considered in what I'm doing.
Okay.
All right, so I will not allow it at this time. So is there anything else that you want to say you're out of time to?
Well, so it should be my turn to cross and comment.
No, you're out of time. You used your time, and I'm not sure it was efficient. Mr. Echard, is there anything else that you absolutely need to show?
Yes, there is one last piece of evidence.
All right, so what is this going to show? This is what we call an offer of proof.
Okay.
All right, I want you to focus on my question, do you?
Yes.
What is this going to show me? Just tell me what it's going to show and say, and where did you, that kind of.
Absolutely. So this is another screenshot of a email she sent me on Friday, asking me to meet up with her. This was after she filed for an order of protection.
Oh, okay.
So I question why and also she got this order of protection after I filed for an injunction against harassment. So the reason I want to present this is to show that she does not feel threatened. The reason why she got the order of protection was to try to silence me. And if she was feeling threatened, she would not ask me to meet up with her. And that's what this piece of evidence shows.
Okay. I want you to know that a person doesn't have to, basically what they're doing is they're coming on a harassment theory, and you don't threaten, you can feel threatened, that is one way to feel harassed. But it's also seriously alarmed, annoyed, or I have the statute here. Where is it? Anyway, but so that's not the only way to be harassed.
I understand.
But in any event, I will consider this. So what is this email? You received this on Friday, okay.
And
What
Your Honor,
exhibit is this, by the way?
This
What
one,
number?
well, I have it as exhibit 35, but I don't know if it got.
How did you label it? You had good labels on it.
Laura asked me to come to sonogram.
Your Honor, I continue to object.
51. Okay, counsel, just a second. I'm trying to, first of all, figure out what exhibit he's talking about. So exhibit 51. All right, and this is he's already laid a foundation saying this is an email from her to him on Friday. What's your objection?
Your Honor, we were only given 20 minutes. She's now 28 minutes here. I haven't gotten a chance to, and if I'm not gonna get a chance.
So it's a time objection. I'll consider your objection in determining how much time to give you, if any. But I'm gonna watch it overruled, okay, if that's your only objection. Go ahead. So I can look that up right now myself, just looking on my computer. All right, so, this was sent last Friday, which was, October 19th? Is that right?
Yes.
All right, and the order of protection was served on October 17th. So, okay, got it. So I've looked at it, she sent you an email, and the terms of the order of protection are that, what, as far as contact terms, only through legal counsel, only in court proceeding, and through electronic mail, only regarding matters pertaining to the paternity. Okay, well, this probably falls within that, so I'm not sure how much traction this gets you. But I admitted it, and I've considered it. I'll decide what weight to give it. Okay? All right. All right. I will give you 2 minutes to cross-examine. That's about how much time I gave him. So.
Okay, you admit that you had sexual relations with Miss Owens, is that correct?
Oral sex was performed, yes.
Okay, and she's allowed to make a pregnancy announcement if she so chooses, is that correct?
Yes.
Okay, she specifically emailed you regarding that she wanted to go to the press, is that correct?
Yes.
Okay, and you emailed back saying that she could essentially go to the press, is that correct?
Not entirely. She had threatened me multiple times to go to the press, and when I realized that
It's a yes or no question.
I said towards the end that if she's gonna go for it.
Didn't you specifically say, I'm unbothered by it all going public, in an email to her on about September 17th, 2023?
Yes.
Okay. Isn't it true that the period for a pregnancy is 40 weeks?
Period of about 9
To
months.
full gestation?
40 weeks, 9 months is what I'm aware of.
Okay. And so from May of 2023 to February of 2024, that's when she could expect to have her children. Is that correct?
Yes.
Okay. You did make those posts online, correct? That we previously showed in the exhibits?
Yes.
And you were made known by Laura that that was disturbing her peace because she was getting harassed by what she felt was you and third parties.
I made those posts to protect my reputation.
Okay. But you did know that her peace was being disturbed, is that correct?
I don't understand why you're asking me this question. I was defending myself, but I was not going after her.
Did she communicate to you that her peace was being disturbed?
At some point, probably.
Okay. And so you were on notice that she was receiving harassing messages, correct?
Yes.
And she actually allowed you to appear on FaceTime at one of her doctor's appointments. Is that correct?
That is false.
Okay. She didn't allow you to appear on FaceTime?
No.
Because he said he was gonna hire actors.
Isn't it true that you said that you wouldn't appear on FaceTime because you wouldn't, you thought that you would hire actors to pretend to be doctors?
No, that is false.
I have an attorney who said that.
Your Honor, no further questions.
Okay, all right. Mr. Echard, I want to give you, you wanted to fully explain one of your answers, and you said it's a yes or no, so I'm going to give you a chance to fully explain that answer if you want to.
Yeah, can you just remind me what that question was again? Sorry, it was kind of a barrage. Which question was that about?
I honestly can't recall. There was, let's see.
I was trying to do it quick. I only had 2 minutes.
I don't know. Is there anything else that you want me to know? I didn't make a note of it, so apparently I didn't think it was all that important.
Yeah, I just want to make note that again, you had mentioned it earlier, but what I've been trying to do is prove that I've been trying to protect my image. Not once have I mentioned her on social media by name. Her name got out there because she opened this court case against me, and that's how it made its way online. So not once have I tried to harass her. You could say maybe she's been harassed by my audience, but that is out of my control as I'm a public figure. What I have done is I have tried to protect my reputation. And the videos that we saw today was me doing so. I've lost thousands of dollars now because of this accusation. Everything that I do is reputation-based. Real estate, speaking on mental health around the country. I train clients online, and I have evidence. I was not able to get to it today, but I have evidence proving I am losing money because of these claims. And so
that's not really relevant.
Okay, so
it is to you,
yeah,
of course. But
I just at the end of it.
Your Honor, I'm going to object now. He was given like a minute to answer the question.
Counsel, sum up in 10 seconds.
Yes. Considering the case of harassment, again, I do not believe that I am the aggressor. I believe she is, and I think that it's baseless that she has presented this to try to put an order of protection against me.
Okay. All right. Let me consider the evidence here.
Your Honor, will my client have an opportunity to speak again? Are we going to be able to make a closing? I think there's some things that are unaddressed that he's clearly gotten more time to speak during this hearing, I think.
Okay. I don't agree. I think that, I balanced efficiency versus the time that was given, and that's my determination. So the answer is no. I gave both of you more time than was allotted, and the differences are de minimis. I want to ask the defendant, did you send that image of, or did you post that image of the plaintiff on the internet? The one, it's Exhibit 11.
No, I did not.
But it says that this post was posted by the one and only Jen. Do you know who that person is?
I do not.
And it was taken down by the moderators of Our Bachelor Nation. Is that the program that you were on, the Bachelor program?
I was on the ABC The Bachelor, yes.
Okay.
And Your Honor, if you're just addressing Exhibit 11, it has to do with the sonogram.
Yeah, because only he was sent that sonogram image. There was nobody else who had it, so it had to be him, and it was within hours of when I sent it to him.
Exhibit 11 is not a sonogram.
Exhibit 11 has a sonogram that in the costume, it has one that I'm supposedly holding. If you look at my hands, it has a sonogram that only he had. That's why I know it was him posting it.
But your lawyer argued that that was something that looks the same? It's so small that I can't, well, maybe I can.
It wasn't the video that looks the same. This was actually a sonographic image that I sent to Clayton because I was concerned about the baby's profile, and that's why I also found it just really offensive that he would
How do you know that this is the sonogram that you sent him though?
I have evidence that I sent him that sonogram. He knows I sent him that sonogram, and I have it in an email.
Yeah, but how do you know that this is the sonogram that you sent him? I'm looking, the one
'cause
that's
it's
in the
exactly
image on
the same.
exhibit, the one that's in the exhibit 11. How do you know that that's the sonogram that you sent him?
Because I sent him an email with that exact sonographic image, because the profile is really distinct, because it doesn't look like the baby even has a nose in it, and that's why I sent it to him within hours. Within hours before that. Nobody else had that because I was concerned about a genetic defect, and I would not have sent that to anybody. That's 100% the same image.
Did you receive a sonogram from her?
Yes, I did.
All right. Is this your photo on exhibit 11, the lady whose image, she's got hair and she's pregnant, is that you?
That's me.
All right. Did you send him a picture that looked like that?
Yes.
I'm not talking about the sonogram. You said that you know that this is you.
Yes, I
from
sent
him
him a
because
picture.
it's got the sonogram.
Yeah.
But more importantly, you sent him this picture of you
Yes.
with your body displayed
bra.
like that.
Yeah.
And you didn't send that to anybody else.
No.
And you're saying the sonogram is the same as well.
Sonogram's exactly the same.
All right. So her testimony is that this picture on exhibit, and that's what I thought you said.
Yeah.
But now you're focusing on the sonogram, which kind of is a distraction almost. But
Okay.
I get it. You're saying that that's how it was posted with someone holding the sonogram.
Yeah.
Okay. And that's you in that picture because that's the picture you sent to him.
Yeah.
All right. Do you admit or deny that? Did she send you this picture of her on exhibit 11 where she, was wearing stretch pants, a bra, and her hair was there and she was pregnant? Did she send you that picture?
Yes, she did send that image.
All right.
I did not, though, post it online.
How do you account for the fact that it's online?
She must have sent it to somebody else. She was sending stuff to the press.
Right. Did you send this photo to the press?
I did not.
Okay. Did you send it to anybody? You're under oath.
No, I did not. And this
Just to Mr. Echard, right?
just to him, yes.
Okay.
May I make a counter to that?
You've denied it. That's a matter of record. Go ahead.
I do know she made a Google Drive available for people to access, and I believe that picture was within that Google Drive. She did make a Google Drive act for people to access.
She denies that though. Okay, but you say that it's there, so, and we don't have it in
Right,
front of me.
correct.
That photo was not there. I was wearing a leopard sports bra in that photo. It was not this photo.
Did you publicly post a picture of yourself that's similar to this?
Not that was similar to this, no.
I'm asking her a question.
Yeah, that's why I stopped.
So,
And it was never publicly posted. It was within a Google Drive that 10 people accessed. But it was not like this, no.
how was it different?
I was wearing a completely different outfit, and I was I wasn't as far along. I had to submit it to the press to prove that I was pregnant.
So you gave it to the press?
But not this photo.
Oh, I see. Okay.
He was the only one that had this photo.
Oh my goodness. All right. please bring me one of my law books? There are two of them back there. Either one. One of them has clips. It's on my credenza behind my desk. Because it'll take me a long time to figure out which. The way domestic violence is defined here, it's in a statute that.
If I may, it's just in regard to the law, what I think applies here, under the domestic statute.
Under what statute?
A.R.S. section 133601. It specifically indicates what domestic violence means.
Right.
And it lists, call it about 20 different ways it can be viewed. And there's
Exactly.
just,
That's kind of where I was going when you
There's
said
just
you
four
wanted
that
to interject. So, okay, go ahead. You're right so far.
okay, so I just wanted to just list four that I think like are applicable in this case. So
Yeah.
which
Which ones do you think apply?
A.R.S. 132904.
2904?
That's correct. That's disorder. That should be disorderly conduct. And then three more, which are A.R.S. section 132916, A.R.S. section 132921, and then possibly A.R.S. section 132921.01. That's just all I wanted to inform the court about.
All right. So tell me, I could pull all these statutes, but what is 2916 real briefly?
2916, just one moment. Use of an electronic communication to terrify, intimidate, threaten, or harass.
Right. I prepared for this hearing yesterday
Okay.
after my calendar was over, and I looked at the petition and I thought, well, which statutes are probably going to be in play? And so I made copies of them, and I did make a copy of that one. And I also made a copy of course, 2921, which is the harassment. So 29, these are all, as he said, in the criminal code, they define domestic violence as any violation of the following statutes, and they're all criminal statutes. And so these are what I call predicate statutes. One of them is A.R.S. 13 is the criminal code. 13-2921 is the harassment statute that's applicable to domestic violence per se. There are other definitions of harassment elsewhere, but they don't apply to this. Then another predicate offense is A.R.S. 13, again, the criminal code. 2916, which is use of an electronic communication to terrify, intimidate, threaten, or harass, and so on. And so, okay, I got that one. So what is the other statute that you want me to, let's see, 2916, got that, that's terror. 2921, we already talked about that, that's harassment. And what's 2921.01?
That one, that was a possibility, but that has to do with, let me just.
I've got the A.R.S. page in front of me too. It's aggravated harassment. That's just like if a person has already been convicted of it and they do it again, then they can be convicted of aggravated harassment. Or they violated an order of protection.
And to be forthcoming, Your Honor, I don't believe that we were able to get in the evidence that would have shown that one. So I believe the ones that most comply are the first three that I gave you.
I see.
Am I able to ask a question?
Just a second, I'm trying to figure this case out. you sent the images to the press, that's similar to this one, only I realize you were at a different stage in your pregnancy and you were wearing different clothes, but you still showed basically your belly. Right. Did you, when you sent it to the press, didn't you know that they could publish that?
They swore to me, it was to page 6, and they swore to me they were not going to publish anything, that it was just for them to confirm that that I was indeed pregnant. But yeah, it was a different image. It was earlier on in the pregnancy.
Did you give them permission to publish that image?
No, and I made sure that I have in writing from them that they were not going to publish it, and they didn't in any of their stories or anything.
Did you give Mr. Echard permission to publish this image in Exhibit 11?
No.
Not the ultrasound, but the...
No.
All right. I'm going to find that the plaintiff has met her burden. One of the predicate offenses here is A.R.S. 13-1425, which is unlawful disclosure of images. The statute is really targeted toward people who send pictures of one another nude or having sex, and then they publish that kind of thing. But then there's also the second, under A.R.S. 13-1425A2. The photo is such that it captures the person, the depicted person who has a reasonable expectation of privacy. And then that's the first sentence. The second sentence, evidence that a person has sent an image to another person using an electronic device does not on its own remove the person's reasonable expectation of privacy for that image. And so, I'm looking at the context of this. There was a dispute as to not only whether she was pregnant with your child, but also whether she was pregnant at all. And she sent this image to you saying that this was her. She's testified that that is her image, and that hasn't been disputed. And she said you're the only person that she sent it to. I realize it's possible that she could have sent it to somebody else who could have published it. That's true. But she denies that. And then I have to decide, would she really want to do that? Because it's not the most flattering picture. That obviously when a person's pregnant, their body's changes. And it's not something that I would think that any woman would want to share. Once in a while you see it, on TV or something. But it's something that I don't believe that she would have wanted to share. And this depiction not only showed her, but it was poking fun at her. And it does seem to suggest that you had a connection with it, because that it does say somehow it connects her to this picture, because it was connected. The Bachelor website saw that. And also it's this idea of this show holding a fake sonogram, or let's see, I have to move the statute out of the way and look at the image again. It was something like making fun of the sonogram, saying, this is all, not true. Real sonogram. Unbrushed wig. The hair is similar, I guess, to the hair that she has. So I'm going to find that posting of that image, publicizing that image, was triggered the domestic violence statute 133601 does include the cite to A.R.S. 1425. I'm going to find that statute applies, and that is the reason I'm affirming that. Oh, and there's an intent that has to be shown as well. And the intent, just the act of disclosing it is unlawful. That would be A.R.S. 1425A2. I'm also going to find that it also violated A.R.S. 1425A3. The image is disclosed with the intent to harm, harass, intimidate, threaten, or coerce the depicted person. And the intent can be filled in by Exhibit 1, which is your email to her that if she goes forward with what I understood to be the paternity claim, that you would hate her and that it would not end well for her. I mean, those aren't exactly what you said, but let me just get the exhibit back up again. You said in particular, what is that? I'll go back to her exhibits, exhibit 1.
Your Honor, am I able to ask a question?
Just a moment, please. Let me just make my record, and then, if you can. I'm not an appropriate person to ask questions of, but I'll listen to your question, but give me a moment to get this out.
Okay.
The bottom of the string says, "I hate you" right now, but there was something here. You better be serious about being pregnant, because if you're not, I'm bringing this all to light. People like you need to be held accountable. You can back off now if this is all a game, and I'll let it go. But if you continue any longer and it's all a lie, I won't hesitate to reveal the truth. One thing about me is when I make up my mind for good, especially when it's rooted in anger, I don't sway ever. Individuals like you that play with people's emotions are the worst kind of person. I've met many, been taken advantage of by many, and I'm sick and tired of being playing nice with them. My hate is toward you and to you only. My hatred would only grow if you decide to put me through all this. I mean, on the one hand, I think it's legitimate to question whether she was pregnant. I think it's legitimate to question whether, even if she is pregnant, whether it's your child. But there are ways of dealing with that, and that would be, going through the paternity case and proving, making her, it's her burden. She has to prove that she's pregnant with your child in order for you to be legally responsible for that child. That's the way to handle it. It's like the common denominator in every order of protection that's affirmed is that people have sometimes really legitimate feelings and rights, like I feel you do. But at the same time, they go about it, they go about vindicating those rights by taking matters into their own hands and using self-help remedies instead of dealing with it through the courts like you're supposed to. And that's where you went wrong. Not that you had your feelings about, questioning this or thinking that it was a fake or that kind of thing are illegitimate. You can think those things if it sounds like you might have had some reason to think that. But the way you published this photo, and which is what I found, I know that you've denied it, but I'm finding that there's really no other accounting for it except if she posted it, and I don't think a woman would have done that in a situation like this. Any person wouldn't have done that. If I before I went on a diet and I took a picture and sent it to somebody, I wouldn't want that picture. It's unflattering. I wouldn't want it. Yes, it's focused on a woman here, but this is something that most humans don't want to have unflattering pictures of themselves posted all over the internet. And so that's my reason for making my decision. And and the intent is proven by Exhibit 1. And I also find that that's a violation, by doing that you violated A.R.S. 13 the harassment statute. A.R.S. 13 2921A causes of communication with another person by verbal, electronic, mechanical, telegraphic, and so on, and written means. And another one is surveys or causes another person to survey the person. I think that is survey may have to be in person. It's not. That term can mean following somebody. It could mean following them and harassing them online. I mean, today, harassment online is just as bad as, almost as bad, possibly worse in some cases, where, you know, it can be magnified by a large public following. That's something that I think, to me at least, just looking at the regular word survey, it doesn't have to say publicly survey, as it does, and like subsection A2, for example, that requires public, that you're following another person in or about a public place after being asked to stop. That doesn't apply here, but I think subsection 3 does, because it doesn't have those limitations about being in public or in person, really. And then I'm also, counsel had suggested that A.R.S. 1329-16 is applicable. Use of an electronic communication to terrorize a person. This one I'm not sure. Let me look at it. I do not find that applies. If one of the subsections, oh, hold on, there's one other thing. I'm looking at 2916, the terrify, intimidate, harass statute. A, subsection 4. It's unlawful for a person to knowingly terrify, intimidate, threaten, or harass a specific person or persons by doing any of the following. I don't think 1 through 3 apply. But subsection 4 might. So let me read it. Without the person's consent and for the purpose of imminently causing the person unwanted physical contact, injury, or harassment by a third party, like a following, for example. Use an electronic communication device to electronically distribute, publish, email, hyperlink, and make available for downloading the person's personal identifying information, including a digital image of the person, and the use does, in fact, incite or produce that unwanted physical contact, injury, or harassment. This paragraph also applies to a person who intends to terrify, intimidate, threaten, or harass an immediate family member of the person whose personal identifying information is used. I don't find that the last sentence applies. There's no evidence that he intended to terrify or intimidate or harass her family, although that might have been the effect of it. I don't think that he had that intent, but I think that he had the intent to do that to you. And so I'm going to find that another applicable statute, which is another predicate in A.R.S. 1336-01, is A.R.S. 1329-16A4. And so those are the reasons for my ruling. Brady does not apply because my understanding is the parties never lived together, right?
Yes, we did not.
So that's required by Brady. So you're not going to lose your gun rights. But obviously you want to be really careful with how you use those. And you've never threatened, personally told her that you're going to harm her. It's just that this, it's almost like you can summon a tsunami with your followers, according to her testimony. Does the plaintiff want, I'm going to answer, I know you have a question, so I'm going to give you a chance to ask it. But before I get there, I want to find out from you, is there anything that you want me to do to modify the order of protection?
I think, we can still have communication about paternity. My main concern with him is that is just that he's going to be posting untrue things that are gonna cause people to harass me. I'm not afraid he's going to physically harm me.
Right.
My concern is more that, but I still think we need to talk about the paternity case because we're both unrepresented in that.
That's fine.
Yeah.
I think that the order of protection itself is broad enough to encompass this idea of continuing to incite people to bother you. And so I choose not to put anything on there because it would be really difficult to write. Why? There are First Amendment concerns here that I don't want to say, don't tell any of your followers anything about your situation with Laura Owens. Well, I'm not sure that that's probably overbroad, but I would be working probably futilely to find the right balance of language here. So I'm just going to leave it. All right, so I'm not going to amend the order of protection. Okay? All right, now, Mr. Echard, you had a question for me. I would, let me just finish this form and then I'm going to be glad to try to at least answer your question. Go ahead.
I'm okay to ask?
Yes.
Okay.
And thank you for waiting patiently.
Yes. My understanding is that this order is going to into effect because the belief is that I was the only one that had access to that photo. If I'm able to prove, which I believe I can prove, that she has sent it to someone else, am I able to get an extension before this ruling?
No.
Because I do believe I can prove that she sent this to other individuals.
Okay.
So what would I guess my question is, how do I go about, because again, my understanding is that's what this is hinging on, and I do believe that I can get credible evidence that she sent this to another individual. So if I'm able to get my hands on that, would that not reverse the ruling?
No. Well, first of all, I'm going to rule now. I do not, this is the time for the hearing. And these are, this is, I don't think it's appropriate here to hold the case open until you can come back with more evidence. So no, I would choose not to do that. I also, and I know that that was my main focus, but I also believe that you talked with your followers about this and that you, she testified that you had made comments about her and how you don't believe her and that she's a liar to your fan base. And I also believe that that is something that can be added as reasons for my decision under the harassment statute. A.R.S. 2921 1A1 and 2. And she came to me for an well, I don't know if I'm allowed to say that. I think if all that we got were a text message from you saying, I hate you, and if you do this, I'm going to be really mad and you're going to regret it. I mean, that could mean a lot of things. It could mean I'm going to sue you and I'm going to have attorneys, follow you to the lawful ends of the earth to the extent that the law allows. That is, yeah, that's scary, but you have the right to do, you can say it once. And if that's all you did, then that I wouldn't have granted an order of protection. But here you not only expressed your intent, but then I find that you followed through with it. And you used the means that were available to you in order to, frankly, get her to stand down and abandon these claims that you're the father of these children, or that I think at some point you accept the fact that she's pregnant, but you're still, and you have the right to still say, I don't believe that this is my child. And that's going to play out in the paternity case. So I hope that answers your question. If not to your satisfaction, at least that's the best I can do. So I'm going to order that because this has been affirmed, that you please leave stuff. Oh, one other thing. I'm making a finding that these acts that I just found had occurred caused I believe that it caused the plaintiff to feel seriously alarmed, annoyed, humiliated, and mentally distressed. And in fact, so that's the, it made her feel that way as a subjective matter. And that it would have caused a reasonable person to feel the same way under the circumstances, so. All right, anyway. So I focused on his intent, her intent. I think I've completely given every reason that I can think of. And of course, anything else that's supported by the record is important. Now, please, everybody going forward, use your legal rights, use your the legal pathways that are available to protect you. And I wish both of you the best. I appreciate your patience with me today. And so please leave separately so there are no hassles out in the parking lot or anything, okay? That's it. What?
Your Honor, now that my legal services have come to an end in this particular matter, I'd like to make an oral motion to withdraw.
Granted.
Thank you, Your Honor.
All right. So who's going to leave first? And does anybody want an escort to their vehicle? Each of you, I'm offering you that. Not me, it'll be an officer.
Yeah.
You can have one.
I would just like to go first.
Sure. Is that okay?
No.
All right. Do either one of you want an escort to your vehicle?
No.
No? Okay.
Okay.
All right, then you're good. All right, good luck to both of you. I hope this eventually blows over for both of you. Good luck.
Thank you.
You're welcome.
Thank you, Your Honor.
Yeah, I'll do that now. Yeah, just bring them in. Laura, bring in the dismissal. I'll do it now before we sign off. I could use a drink of water. Oh, you're good. Yeah, thank you. I'm going to ask you guys to wait out in the hall, please.
Okay.
But give them 10 minutes or so to get up.
Okay.
Properly. All right?
Oh, yeah, no problem.
Thank you.
You're welcome. You left our adapter?
Yeah, it's right there.
Thank you. All right. We don't want those walking out. That's something I would do, by the way, inadvertently. All right, good luck.
Thank you so much.
You're very welcome.